Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is on artificial intelligence and voices. Befitting this program, the voice and person you are watching and listening to right now is me. Well, sort of. This is my digital avatar and an artificial intelligence creation of my voice. Really, I'm telling the truth? It felt particularly fitting to use this technology for our program today on artificial intelligence and voices. Rest assured, all of the words that I am speaking to you today, I indeed sat down and wrote along with the PowerPoint presentation. And then I uploaded it to the artificial intelligence software, which software was able to learn my voice by listening to a variety of my speech recordings. It's genuinely incredible because I see and hear this and I fully know that it is me. Yet it is my digital avatar performing as me. Thus, instead of me speaking these words in real time into a camera, as is normally the case, here I uploaded the script into software and lo and behold, there I am speaking to you. And on top of voice, we have a full digital avatar of me that was prepared by the same artificial intelligence and advanced software technologies that allowed me to stand before a camera and speak for a while, at which point it is able to recreate me with facial gestures and hand gestures. And these are the early days of the technology. In only 10 years, I can only imagine how it will be. This is why, of course, it collides with the law and we need to do a legal program on it. So as we learn about artificial intelligence and voices, the entire program itself is built on the very same technology, which is genuinely incredible and amazing. Briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that in fact has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our exploration of AI and voice, and where AI collides with the law in this brave new world that we are all entering. Let's get going and talk about the legal issues as we discuss voice and sound alikes. From a big picture standpoint, The issues we will address relate to the idea that voices, like your likeness or image, are part of your personal brand, so to speak, and they have value because they connote a source, you. The question then is, can we as people control other people's use of voices that sound like us? This matters immensely to all of us, but especially to unique signature voices that may have found commercial acclaim or recognition, and as a result, financial success because of the voice. This also relates to the value that others then see in that voice, which could be used for commercial purposes to trade off the voice. For example, you can easily imagine, as we will talk about here, the value of a very famous celebrity's voice being appended to a good or service. I, for one, would love to have the voice you hear when you go to my law firm's website, be that of Morgan Freeman, saying that we are the greatest intellectual property lawyers in the world. Alas, we don't do that for reasons you will find out shortly. Although today we are talking about artificial intelligence and modern technologies, the issue of voices and the value of them is not suddenly new. They are actually, in our commercial world, old age issues that have tracked with the development of technology from the earliest radio and television days, as we will see in cases, to the more modern technology era where, in light of technology, we now can create sound-alikes that do not depend upon a human being learning to mimic someone else. And with the modern AI technology, what we now confront is the ability to have this technology be employed on a large scale, relatively inexpensively, in ways that can be used for good, or in ways that could be used, unfortunately, for ill. This leads us to address at the outset artificial intelligence. What is it exactly? And how does it work? This will then lead us into a review of the relevant legal regimes that intersect with artificial intelligence, specifically an overview of the right of publicity laws. We will look at the substantive standards that apply, and how within the realm of right of publicity law, voices in particular can find protection. We will also do a quick little visit to the copyright garden as we explore the Scarlett Johansson case. As a result, we will traverse through all the technology ages, starting with the actor who played the lion from The Wizard of Oz, Burt Lair. We will then go into the 1970s and look at a case involving Nancy Sinatra and the famous song, "These Boots Are Made for Walking." We will move into the 1980s with a famous case involving Bette Midler, who found a voice alike singing one of her songs in a commercial for Ford to sell the Ford Mercury Sable car. We will continue into the 1990s with famous singer Tom Waits, who also confronted a situation similar to Bette Midler. Only this time it was not cars being sold, it was potato chips. And as we move into the 21st century, we will look at the case of Val Kilmer and some incredible technology that allowed him, given his health issues, to have his voice return to the screen. I'm sure you all saw the new Top Gun Maverick movie, which employed that technology we will talk about shortly. If you did not, it's a great movie. Go see it. And finally, this will bring us to the 2024 situation of Scarlett Johansson and the use by OpenAI ChatGPT of a voice that she felt sounded like her voice being used as the AI voice assistant. Let's start with some basics, however, and address the issue of what exactly is artificial intelligence and how is AI working. It's an advanced computer generative learning system that works from algorithms and human-based reinforcement that augments the subsequent machine learning that can be done working on massive data sets. The result is a computer system that is able to complete tasks that would otherwise require cognition. This exploded into the public in late 2022 when OpenAI ChatGPT was released. So let's talk quickly about what is GPT. GPT is known as Generative Pre-trained Transformer, and it uses a language model that uses machine learning techniques to create human-like text in various forms. It is built and trained on a massive data set of content. It then uses that data set to predict words and sequences and develop learning from complex data patterns and natural language learning. This one was trained on 500 billion tokens, which allow its language models to more easily assign meaning and predict plausible follow-on text. Many words map to single tokens. The longer or more complex words can get multiple tokens. On average, tokens are roughly 4 characters long. So, with the ChatGPT neural network, there are 175 billion parameters or variables that allow it to take your input. And then, based on the values and weightings it gives to the different parameters, coupled with some randomness, it will then output whatever it thinks best matches your request. Randomness, you ask? Yes, the exact same question posed by 2 people can and will get slight variations in answers because it runs the prompt through the system each time anew. This is significant because it is not hitting a database to find an answer, as most of our computer experience has led us to understand how data retrieval work. But is there also the potential for direct copying? Yes, there is. If you prompt it to identify who you are, for example, it may just draw content from your online bio. For example, I have done this for myself, and because I am not a famous person with vaults of information online about me, it simply gave me back a variety of content that came from my online biography on my resume. Finally, what is critical is that it can learn on content such as text and documents, but it can also learn on images and pictures, and for our purposes here today, voice. These learning networks, also called neural networks, can artificially construct voices, capturing the basic patterns of human speech. The AI listens in effect to massive amounts of data, millions or billions of hours of human speech, and it does this to identify the vocal characteristics of how people speak, their patterns, intonations, pauses, rising, falling, everything that we do when we speak. With enough training, the AI can ultimately replicate speech and all its nuanced intonations with startling accuracy. Just as I said in the beginning, it is remarkably doing so here today on Yes Me. So here on this slide, you can see an example of a query that I personally put into ChatGPT. I asked it to write a song that sounds like the Beatles, but is a new song. Now, I did not ask it to write the sheet music or create the actual sound recording, although artificial intelligence can also do that. I just wanted an actual written song. And you can read and see the song here. I will not read it to you, but you can check it out later. And you will find that it actually does feel reminiscent of the types of songs that the Beatles wrote. That then gives us an overview of artificial intelligence, so let's dive into voice. I told you in the beginning that this technology can be used both for good and ill within the framework of our legal system. And so I want to talk about a positive example of this technology out of the gate. This is the situation involving Val Kilmer, and this is a positive story as it relates to the legal regime, as well as just being a positive feel-good story. But specifically, it's a situation of artificial intelligence learning Val Kilmer's voice with his consent. So what you need to know by way of background, if you don't already know it, is that Val Kilmer had some sort of an illness that has damaged his vocal cords, such that he cannot speak in his familiar, well-known voice anymore. Now, 20 years ago even, that would be the end of an actor or a voice actor's career, obviously. But not anymore. With artificial intelligence, because Val Kilmer was able to have his voice recreated by listening to and learning off of historical recordings of his voice by way of a company called Sonantic. So check out this YouTube video, which will show you the most amazing technology in terms of voice and artificial intelligence.
We all have the capacity to be creative. We're all driven to share our deepest dreams and ideas with the world. When we think of the most talented creative people, they speak to us in a unique way. A phrase we often hear is having a creative voice. But I was struck by throat cancer. After getting treated, my voice as I knew it was taken away from me. People around me struggle to understand me when I'm talking. But despite all that, I still feel I'm the exact same person.
Now there you saw the case of consent. But I want to stand and deliver out of the gate and show you the opposite case that we will be exploring as this program continues today. So let's take a look right away at the Scarlett Johansson voice situation. That led to a controversy because it was not done with her consent. I'm not going to answer all your questions right now about how this collides with the right of publicity, but they will all be answered by the end of this program. So check out this video released by OpenAI showcasing their virtual assistant named Sky. You need to watch and listen to this to understand the legal and factual questions the law will need to answer.
From right of the ChatGPT app, and this will open up GPT-4o's audio capabilities. Hey, ChatGPT, I'm Mark. How are you?
Oh, Mark. I'm doing great. Thanks for asking. How about you?
Hey, so I'm on stage right now. I'm doing a live demo, and frankly, I'm feeling a little bit nervous. Can you help me calm my nerves a little bit?
Oh, you're doing a live demo right now? That's awesome. Just take a deep breath. And remember, you're the expert here.
So let's dive into the law. This requires us to look at the right of publicity. What is the right of publicity? Well, it is a state-based right that exists in many states, but not all. It exists both in common law form as created by courts, but also as positive enacted law by legislatures in various states. At its core, it is the right to protect against an unauthorized use of one's name, image, likeness, voice, in a manner for commercial gain. You can think of it as a root right of every person to control the commercial exploitation of his or her identity. In some sense, it is a form of personalized intellectual property in ourself. Does this right survive death? It does in many states. Some states, however, require that a person's name or likeness or voice have commercial value at their death in order for that right to survive their death and go to their heirs. For example, California and Texas are two states that have this requirement. What this means is that, at my death, in California, it will not in all likelihood survive because there is no real value to my voice, and so my children are out of luck. If someone chooses to exploit this voice you are listening to down the road. But if you are Humphrey Bogart, for example, or James Dean, or pick any other famous celebrity, this can have massive value to their heirs. And one thing you will see quickly is that, in light of the new artificial intelligence technologies that can recreate voices and put them in new scenes and settings, which could never have happened before, it has created a massive economic gain to the heirs of deceased celebrities. Just stop and think, for example, about Humphrey Bogart. When he died, he could no longer appear in movies and could no longer sponsor goods or services because he was dead and his voice was gone forever. But now, artificial intelligence can exhume his voice and, if his heirs want, he could be sponsoring goods or services. And, as artificial intelligence develops even more, in coming years, he will actually be able to act in movies again. I, for one, want to see Casablanca Part 2, to see what happened when Rick and Louie walked off the tarmac at the end of the movie. Let's hope it happens. In any event, back to the law. These rights can last, if they do exist, post-death from 10 to 100 years. If you just stop and think about the state of technology 100 years ago compared to today, we probably cannot even fully comprehend the technological advances that will happen in the next 100 years, given the growing pace and rate of technology changes. Legally, what this means is that these rights are immensely valuable. So where does this personal right of what we could call our personal intellectual property come from? It was first conceptualized in 1890 by Samuel Warren and Louis Brandeis in a famous law review article called The Right to Privacy, published in the Harvard Law Review. This was before Brandeis became a Supreme Court justice. It then existed at common law in various states over the subsequent decades and began being codified as positive law in various states also. For example, in California, it was codified in the 1970s. It's now recognized in over 35 states, and what is critical to keep in mind is that this is a distinct right to copyright or trademark, even though it has similar issues and touches on similar concerns. The existence of this right in the state courts eventually reached the U.S. Supreme Court in the late 1970s. This was a case involving the famous human cannonball. You can see the case there, the case and its citation, so you can read it later. But basically what happened is as follows. The human cannonball had an act that he made money performing. He would drive his large truck that had a cannon attached to it, wear his cannonball suit, climb into the cannon, and then get fired out of it. He would fly through the air, flip, and land. That was his whole persona. It took only 15 seconds. And he made his living by charging to watch the short event. So for him, the 15 seconds were everything. What happened is that a reporter video recorded the whole act and played it on the news. The human cannonball then filed a lawsuit under Ohio's right of publicity laws, claiming that his persona, that is his act that he did, was that entire short video sequence, and showing that to the public abridged his rights. The news organizations claimed a First and 14th Amendment right to broadcast this as news. But the U.S. Supreme Court rejected that argument and found that he had that right that was free from complete exploitation. Now, what is important for our modern artificial intelligence age, in light of the fact that the U.S. Supreme Court has only addressed the right of publicity and the First Amendment one time, is the fact that the decision was a 5-4 decision. And the legal fault line the decision hinged on was the fact that the news organizations engaged in conduct that amounted to an entire taking of his performance, as opposed to merely reporting upon it, which would not require such an extensive taking, arguably. This is what the U.S. Supreme Court said. Wherever the line in particular situations is to be drawn between media reports that are protected and those that are not, we are quite sure that the First and 14th Amendments do not immunize the media when they broadcast a performer's entire act without his consent. On the other hand, the 4 dissenting justices took the position that it was genuinely news activities and therefore protected by the First Amendment. The dissenters stated as follows. Quote, "There is no suggestion here that respondent made any such use of the film. Instead, it simply reported on what petitioner concedes to be a newsworthy event, in a way hardly surprising for a television station by means of film coverage. The report was part of an ordinary daily news program consuming a total of 15 seconds. It is a routine example of the press fulfilling the informing function so vital to our system." End quote. The decision was from the 1970s, but here is the breakdown of who the dissenters were. This is important to us as IP and right of publicity lawyers because we want to try to read the tea leaves about how today's court would rule. The 4 dissenters were Justices Marshall, Brennan, Stevens, and Powell. In other words, the liberals of the court of that era, by and large. Now, the majority was Justices Berger, White, Rehnquist, Stewart, and Blackmun, the conservatives, by and large. But you will note that it was not a purely right and left split, given where Powell and Blackmun came down. So it is an important decision, but we can also see that it was a very closely decided case that hinged on a very unique and arguably extreme fact pattern in terms of the entire taking. Nonetheless, this decision really coincided with the floodgates opening in reality to the modern right of publicity age in terms of protections and monetization of it. This has led to further enactments of laws in various states, which also include rights in some circumstances for broadcasting, but not the right for a complete taking of someone's persona in general. So let us now unpackage this right a little bit more. We will look at the California statutory right, which is codified in California Civil Code Section 3344. It protects against an unauthorized use of a person's name, likeness, voice, signature, and/or photograph in commercial advertising. Subsection A provides that any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner on or in products, merchandise, or goods, or for purposes of advertising or selling or soliciting purchases of products without the consent of the owner is liable for damages. There are augmented damages and punitive damages available, along with attorney's fees also. So it is a powerful right that gives remedies if it is abridged. As I mentioned before, there are some statutory limits that have been enacted. For example, California has an explicit exception for uses in connection with any news, public affairs, or sports broadcast or account, or any political campaign. This allows news broadcasters to show, for example, athletes either in public or in clips of them playing, without being sued by them for right of publicity. But remember, the human cannonball case still stands as good law, so a complete taking of someone's persona, which is their entire economic persona value, would create an issue. There are further statutory exemptions from liability for uses in a play, book, magazine, newspaper, musical composition, audio-visual work, radio or television program, or other types of newsworthy events. This is where the First Amendment has been enshrined and protected as a limit on the scope of the positive right, so that, for example, documentaries and biographies can be made of famous people. Even then, of course, as an intellectual property lawyer, I can tell you that we regularly confront the issue of whether a use is too extensive and whether rights should be cleared to avoid even uncertainty of potential litigation. And for those of you back east, New York is similar with similar laws that it has codified and enacted. So let's get going on our first case in the earlier technology age, which brings us to The Wizard of Oz. This case involved the actor who played the lion, Burt Lair. He had a very unique voice that was in the films he appeared in, as well as in cartoons where he was the voice character. Let's start by watching this small clip to understand his voice and its unique place in that time's commercial marketplace. This is critical to understand the law and facts, and ultimately the court's holding.
I got a number 1, 2. I got a number 3, 4. I got a number woof, woof. I got a number eyes a muggin'. 1, 2, 3, 4, 5, 6, 7, 8, woof. 11, 12, woof, woof. 14, 15, woof, woof. Have you ever felt a feeling for the delta? Zaz, in the Mississippi mud. It's a treat to beat your feet on the Mississippi Basin. M-I-S, south in my mouth. Christopher Columbus. Oh, you rascal. Yeah, man, hot dog. Well, burn my clothes. Oh, that tiger. Oh, that tiger. That tiger. That tiger.
Now you understand who he was. What happened in that case is that the defendant chemical company used a voice actor who specialized in imitating his voice as the voice of a duck in a commercial for a product. Plaintiff filed a lawsuit as a result for invasion of privacy and unfair competition, the common law torts that frame and are foundational to what is today the statutory right of publicity. The plaintiff, our lion from The Wizard of Oz, claimed that his style of vocal comic delivery was distinctive and had an original combination of pitch, inflection, accent, and comic sounds that had caused him to become widely known and readily recognized as a unique and extraordinary comic character. The case was dismissed at the pleadings, but he appealed to the First Circuit in 1962, and you have the reported decision if you want to go read it, which is actually a fun decision to read, and here is what the court held. The court started by limiting the scope of any such rights, focusing on the fact that the law would not sustain the idea that any time someone can allege that a commercial sounded like me but was poorly done, and as a result contend that the public believed that it was the person, the consequences would be too great to contemplate. As a result, it narrowly framed this right of publicity claim, being heard through unfair competition torts, but still found for our famous lion in the following way. The court focused on the fact that the plaintiff's complaint had zeroed in on the idea that the defendant was stealing his thunder in the most direct sense, and that the defendant's commercial and its product ultimately had greater value, because the audience actually did believe that it was listening to the plaintiff. Because the plaintiff alleged a peculiar and unique style and type of performance, the First Circuit held that he should be allowed to get into discovery to test his case without being rejected as a matter of law. This now brings us to the 1970s in the Ninth Circuit. In this case, Nancy Sinatra sued the Goodyear Tire and Rubber Company, making similar California tort claims to our famed lion, related to her alleged iconic style of singing and dancing that had become famous from her song, "These Boots Are Made for Walking." If you are not familiar with her song and the video that was made, you can go find copies of it on YouTube, but basically, it is that famous song she sang with women in short go-go dresses and boots dancing. You can see a screenshot of the style that she was claiming protection over on our slide here. Let's now watch what Goodyear did with its commercial. Keep in mind as you watch it both the fact that the claim involves the performance style and voice similarity. That will become key to understanding the holding. Here you go!
What are the hot cars wearing this year? Boots. Wide boots, GT tires from Goodyear.
These boots are made for rolling wherever cars are hot. Wide boots, GT from Goodyear. What sports cars need, they've got.
Check the specs. Built low and wide like racing tires. Low cord angle. 4 plies polyester cord. Track tested at 130.
These boots are made for rolling wherever cars are hot. Wide boots, GT from Goodyear. What sports cars need, they've got.
If If you drive a high-performance car, you need Goodyear's finest high-performance tire.
So, there you see it. It was using someone who sounded like her. It had the look and the feel of the women in the short go-go dresses and boots. And it was a different version of the song that was somewhat ironic or funny, you could say, in terms of being related to cars and the sale of tires for cars. What did the Ninth Circuit do with her lawsuit when she sued? The Ninth Circuit Court of Appeals, as you see here, held that Nancy Sinatra and the Goodyear Tire Company were not in competition in any manner. And so, therefore, Goodyear was not passing off its tires as her products, nor was it passing off her records as its products. Given this narrow focus of California's passing off law, it held that her claim was rejected. Specifically, it focused on the fact that there is no federal copyright interest that allows one to control their performance, such that others are not allowed to make similar musical performances. And at the same time, there was no holding out by Goodyear of the video as being one of her performing in it. That is, a particular form of performance, such as women in boots and short dresses, could not be monopolized under federal law, and so state law could not conflict. As a result, the Ninth Circuit felt that she was encroaching into federal law too much with her state theory. What is important is that the court held this even though it assumed, as found by the district court, that the voice did in fact sound like Nancy Sinatra's voice as an imitation singer. Basically, her theory was too broad. So, as you can see, as it stands at this point in time, at least in California, attempting to control one's voice was not working for Nancy Sinatra. But in large part, that could have been because of the overly broad nature of her challenge to try to control more than just a voice alike and focus more on the ability to control others' performances, which slid into the realm of federal copyright law too much. This will now bring us to the 1980s, where another performer confronted a somewhat similar situation. And this time, the plaintiff did not bring such a broad theory, but focused on a narrower theory under state right of publicity law. Let's look at Bette Midler and her battles in the Ninth Circuit in the 1980s. In the 1980s, we can consider the case of Bette Midler versus Ford, which went up to the Ninth Circuit in 1988, and you can read the opinion at 849 F. 2nd 460. Let me give you the facts before we actually watch the commercial that upset Midler. Ford Motor Company wanted to do an ad campaign for its Mercury Sable car that was meant to inspire nostalgia for the 1970s. As a result, it wanted a famous 1970s song to be sung by the original artist who recorded it. It chose the song Do You Want to Dance, which was one of the songs Bette Midler recorded on one of her commercial music albums. The Ford Motor Company cleared the copyright interests from the copyright holder of the musical composition, which was not Bette Midler, and it then asked Bette Midler to record the song for the commercial. She did not want to do it, and so as a result, Ford hired a voice impersonator of Midler and had that person sing the song, and Ford also did not use her name or image in the commercial. In other words, it did not use someone who looked like her and perhaps danced like her, as in the case of Nancy Sinatra and the Goodyear Tire Company. It got a sound-alike. Let's now watch the commercial. I have only taken part of it, enough for you to get the idea of what was happening as it relates to a voice impersonation claim. If you want to see it all, the YouTube link is there for you.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road. Introducing Sable. Mercury, the shape you want to be in.
Well, there you have it. And what did the Ninth Circuit hold? You can see the holding there, which sums up the right of publicity standard pretty well. The court held, why did the defendants ask her to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct that sound-alike to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of her identity. Its value was what the market would have paid for her to sing the commercial in person. And here is a key line which now echoes through the decades to our modern day. The human voice is one of the most palpable ways identity is manifested. The Ninth Circuit also addressed these First Amendment concerns that we have already alluded to in the human cannonball case, and in the statutory exceptions, by noting that the First Amendment is broad and gives a lot of leeway to the press. But where the purpose of a use in media is informative or cultural, then that use can be immune in terms of First Amendment news-gathering issues. But if the media's use of a person's identity is centrally related to exploiting the individual portrayed for commercial gain, then the First Amendment gates are essentially slammed shut, and there will be no immunity. This is a massive case in the realm of voice that has long-lasting consequences as we enter the artificial intelligence age, where voices can now be recreated without having to hire expensive imitator actors. Finally, it is also worth mentioning what happened after the Ninth Circuit remanded the case. Well, it went to trial, and the jury awarded Bette Midler $400,000 in damages. The defendants appealed it all the way to the United States Supreme Court, but the Supreme Court refused to take up the case. Before we get to the modern AI age, there is one more stop, and that is the case of Tom Waits against the Frito-Lay potato chip company. This case picked up on the Bette Midler case. It is reported at 978 F. 2nd 1093 from the Ninth Circuit in 1992. This time, singer Tom Waits found that a voice imitator had sang in a voice that sounded like his famed raspy voice in a commercial for Doritos. He was concerned because he realized immediately that anyone that saw the commercial and heard the commercial would assume that he had done a commercial for Doritos. And this particularly bothered him because he had made it a point in his career to not be commercial at all, often stating that artists should not do commercials because it damages their craft. Let's first check out part of the commercial.
There's a new tortilla chip called Salsa Rio Doritos. It's Buffalo, Bafo, Bravo, Gung-Ho, Tally-Ho, but never mellow.
Tickle your taste from the tangy tomatoes, flavor peppers, oodles of onions and sassy spices. A new Salsa Rio Doritos.
Now that tongue tickler's quite a stickler. It's confounding, resounding, perplexing, complexing, involuted, convoluted, but it sure feels.
Well, after that commercial and his lawsuit, the case went before a jury. The jury in turn awarded him $2.6 million in compensatory damages, punitive damages, as well as attorney's fees. The facts here, as in Midler, showed that the defendant specifically hired a sound-alike and really wanted a commercial that evoked Tom's voice. Somewhat similar to the Nancy Sinatra case, the defendant tried to argue that the federal copyright laws controlled and should not allow the right of publicity laws to be used in this way. But the Ninth Circuit rejected that argument. The court found that the situation was one of a deliberate imitation of his voice, as opposed to simply appropriating his style, and that his voice was sufficiently distinctive and widely known to give him a protectable right under California right of publicity laws. See here the bolded language, which is important, where the court held that this claim was based on an invasion of a personal property right, the right to control the use of a person's identity, where that identity is embodied in voice. So now let's enter the 21st century and the realm of artificial intelligence and the Scarlett Johansson situation of 2024. In 2024, the facts as publicly reported appear as follows. OpenAI asked her if they could use her voice as a voice in the artificial intelligence systems they were creating. Imagine something like Siri that we all know from our Apple phones, but far more advanced. She declined. Nonetheless, OpenAI then released its most recent version of ChatGPT with a voice assistant who goes by the name of Sky. When the commercial was released, many people felt as if Sky sounded like Scarlett Johansson. She certainly did, and it is reported that she hired lawyers and complained. No doubt her lawyer's letter cited the Bette Midler and Tom Waits cases. Here is the commercial again, so you listen for yourself and make your own decisions about the legal and factual questions of similarity and use. We will then discuss it within the right of publicity framework. Here you go.
From right of the ChatGPT app, and this will open up GPT-4o's audio capabilities. Hey, ChatGPT, I'm Mark. How are you?
Oh, Mark. I'm doing great. Thanks for asking. How about you?
Hey, so I'm on stage right now. I'm doing a live demo, and frankly, I'm feeling a little bit nervous. Can you help me calm my nerves a little bit?
Oh, you're doing a live demo right now? That's awesome. Just take a deep breath. And remember, you're the expert here.
Now, to be clear, this is not a slam dunk. Many people, when you read online discussions, say that it does not sound like her. This gets to one of the core fact issues that exists in these voice cases. Is the second voice, in fact, an imitation of the first voice? We don't know what happened in the conversations between her lawyers and OpenAI, of course. But Sky has been taken down in terms of that voice. And this raises a variety of issues. First, was the voice of Sky AI generated, or was it a voice imitator actor? If it was a human actor, then this looks very much like the Midler and Waits case, which would then raise the legal questions within right of publicity law of whether this was a knowing use of her distinctive and valuable voice in a commercial manner. After all, they tried to hire her and she refused. This fact is powerful to merge with facts of voice similarity to conclude the second voice is indeed a copy of hers. Second, there still remain complex fact questions about the distinctiveness of the voice. A Midler sound-alike singing a Midler song on those facts seems easier. The same for Waits with his particularly unique raspy voice. But it gets harder when a voice is not being used in an associational manner with the person, as was squarely the case in Midler, and just sounds a bit like someone who is not known for a distinctive voice, in contrast to the Waits case or our lion from The Wizard of Oz. On the other hand, if the voice was AI generated, then it raises similar right of publicity questions. As a factual matter, it obviously gets more complicated because a voice imitator is hired to imitate a voice, and that makes proof of the knowing element easier. But whether the AI machine has learned human voices by listening to thousands or millions of hours of human voice and has generated that voice is a slightly different question. It is harder to prove that it was trained on her voice in particular, or whether it was simply trained on voices and the voice it landed on sounded somewhat like hers. In other words, was this a knowing use under right of publicity law? This is where we have our little trip into the copyright garden very quickly. Let's imagine a hypothetical, whereby the company did want to imitate Scarlett Johansson's voice. After all, apparently it asked for her permission and she declined, and let's then assume that what it did was have the artificial intelligence machines learn her voice. Let me double-click on that for you to explore our little copyright sidebar. The generative machine could theoretically learn her voice by listening to many hours of her movies where her voice has obviously been recorded. If hypothetically this occurred, then this is what brings us to our copyright question. The owners of the sound recording of her voice and copyright would be in all likelihood the film studios that retain the copyright to the movies that actors appear in. And the studios could then make the argument that the machines, in order to learn her voice, had to record and download those movie scenes, which acts are acts of copyright infringement, arguably under 17 U.S.C. Section 106, that gives copyright owners the exclusive right to reproduce, copy, and download their content. This is where copyright law is important, because the AI machines are not just listening in an abstract or sterile sense. To study the voice, the AI technology needs to download and study the information. That act of downloading is what triggers, arguably, the copyright violation of the exclusive right to make copies. Indeed, these very cases are currently being litigated in a variety of realms, from photographers to authors to even famous comedians. And the copyright issues are not clear-cut. The defendants in these cases are arguing that their use is a fair use under the Copyright Act. There is an important fair use opinion already in the law in this area from a few years ago when Google Books set out to copy all books ever published, and then make small snippets of those books available via the Google search engine. The case went to the Southern District of New York, and after lengthy litigation, the court held that Google's use was a fair use because it was transformative. It was transformative because it made the books available for the Google search service that did not compete with book publishers. This decision, then, is at the heart of the legal battles today over whether the AI learning on data, content, voices, or images is also a transformative one. Stay tuned, as there are no clear answers yet. As a result, this landscape in the voice context could then mean that a defendant company would face a dual set of claims. One from the underlying actor, claiming a right of publicity misappropriation of their voice in terms of the digital imitation being used knowingly to create an affiliation with her in order for commercial gain. And the second claim would be one of copyright infringement in terms of how the machine even learned the voice to begin with. This potential dual regime of liability, of course, creates massive commercial uncertainty, which in turn furthers the need to develop clearer rules for this technology in our new AI age. Let's now take a slightly different version of this fact pattern. Assume that AI generative machines have simply listened to millions or billions of hours of human voices and have categorized them also in terms of adjectives or descriptions that we use to categorize a voice, such as raspy, high-pitched, booming, soft, kind, sultry, you name it. And then when someone asks for a voice of a particular kind, it generates a voice with signals similar to categorized voices. If there sounds some similarity to, for example, Scarlett Johansson in that situation, it is harder to cognize that as a knowing use of her voice. After all, if you bring this to the analog age again, a famous voice, even if it is raspy and gravelly, cannot stop another human being from singing just because that human being happens to also have a similarly raspy or gravelly voice. Let's again double-click. Let's, in the spirit of this AI program, use me as an example. So when I was in law school and grades were posted, I did well. A law student came up to me after grades were released and said to me that she was surprised I did well since she thought I was a dumb surfer from when I spoke in class. Now, I do not surf, but put that aside for our hypothetical. Now imagine an AI voice machine creates a voice that sounds like me. It did this by simply listening and learning inflection and speech patterns from thousands or millions of people. And imagine someone says they want a dumb surfer voice, and out comes a voice that sounds like me. Put aside, I'd be horrified that even AI thought like the law student, but that aside, in our hypothetical, it did not study me in particular. For me to make a claim against the software company of a knowing use would suddenly become much harder. This is a good example of the limits that current right of publicity laws as applied to voices in the AI age. Let's get back to right of publicity now. One of the questions that all of these cases have raised, which is even more pressing arguably in this modern AI age, is the need for a federal right of publicity in order to have uniformity. As you will recall from the beginning of this program, there is a hodgepodge of state-based rights in various states. The states, however, differ in terms of the scope of protection, the types of remedies one can get, as well as whether there is even a post-mortem right of publicity available. Even before the digital age, this created forum shopping issues that can occur. For example, a plaintiff may have a claim in California, but not Alaska, and that leads to suits filed in California to avoid risks in Alaska. Or a state may have better damages remedies. Some states even have laws that state anyone in the nation can sue under their statute, assuming minimum contacts over the defendant, of course. Other states do not have such breadth of laws, and states can differ on the scope of the right. California's voice protection may not, for example, reach voices in other states. This creates conflicting state rules on questions as fundamental as whether someone even has a right to begin with. When we contemplate the digital and artificial intelligence world, the problems magnify. Technology that allows videos to be created of people, digital avatars that is, as well as digital voice replications of people, also allows these videos to be disseminated across YouTube, Snapchat, Facebook, all manner of social media, rapidly and easily. This includes the terrible cases of deep fake pornography that have been publicized, such as of Taylor Swift and others. And so this too raises the question of the need for a uniform national right. Today, with much greater ease of access to the technology by all people to create digital replicas of others, which in the pre-digital age was not nearly as easy, obviously, we now have the likelihood of far more violations of these rights of publicity. And, of course, there is a massive issue. If certain people in certain states lack protection, other people in other states have protection. And even more broadly, if even in states where there is protection, we have situations where people have to go to state court to get an injunction, which may or may not have applicability to social media platforms in other states and would be very complicated to enforce. All of this has raised real questions about the need to have a national right of publicity, with federal court jurisdiction and nationwide jurisdiction from those courts, in order to protect people's rights of publicity. Much has been written in this in legal journals. You can even find an article I wrote on my bio on my law firm's website. In short, artificial intelligence is pressing very hard against the variety of different state law regimes we confront protecting these rights, and is really testing the limits of our current legal landscape. There's a very strong case that can be made that there needs to be a complete nationalization of the right of publicity, similar to the way copyrights, trademarks, patents, and even trade secrets have federal protections. These federal rights allow faster and more robust enforcement for protection. But will it happen? There are some green shoots growing out of the ground with some early answers to this. As of 2024, there are a couple of pending bills in Congress to address the issues of artificial intelligence and deepfakes, principally due to the revenge porn and pornographic case examples that have come out in the media regarding digital avatars. Let's now take a look at one of these pending acts, known as the Deepfakes Accountability Act. This act, if passed, creates a legal obligation for those who create deepfakes through generative artificial intelligence and do not label the video or audio file as having been made through AI. It applies to both living and deceased people. And a deepfake is defined as having been made by generative artificial intelligence, whereby it appears to authentically depict either the speech or conduct of a person who did not engage in that speech or conduct.
Note, however, actors who do verbal impersonations.
I won't read the whole definition for you, but you can see it here for a few moments and study it further in the materials. If someone makes such AI deepfake content and does so with the intent to distribute it over the internet, or even with knowledge that it will be distributed over the internet, then they must make sure that the file clearly identifies itself as being made through technology with altered audio or visual elements or having been created by AI. There are specific labeling requirements the law will require in terms of a verbal statement that identifies the use of artificial intelligence, as well as a clear, written statement in readable text throughout the whole video, identifying it as having been made by artificial intelligence. And no, this does not mean you can make deepfake porn of people and just label it. Sexual deepfakes are to be per se outlawed. I have bolded the content for you to read here that is germane to our discussion today. Thus, as you can see, there are criminal penalties for those who fail to disclose. It is to be criminal to make deepfake porn where the deepfake contains sexual content or visual nudity and appears to simulate people engaging in sexual activity, as well as videos that are made with the intent to cause violence, harm, or diplomatic conflict, or interfere in official elections, assuming the advanced record does in fact pose a credible threat of instigating such conduct. It will also apply to the use of deepfakes in identity theft, wire fraud, securities fraud, and apply to any foreign power or agents of foreign governments who act with the intent to influence any kind of a public policy debate or even an election. As you can see, there are some pretty facially broad applications of this statute, which in some of these contexts may well collide with the First Amendment as currently structured. Specifically, there will be questions raised about the ability to criminalize speech that influences a public policy debate. One can imagine that all manner of speech about social issues, such as abortion or the right to have guns or immigration policy, relates to public policy debates, and this act will, if passed, criminalize foreign agents from engaging in that speech on our media platforms. Moreover, there are provisions for civil liability. These actually track somewhat existing remedial structures that exist in the U.S. Copyright Act. And what the statute as envisioned provides is that if someone has been exhibited and engaging in activity that is falsified by way of deepfake technology, then they may seek damages and injunctive relief in federal court. The statutory damages structure includes a $50,000 penalty, a $100,000 penalty, potentially if the conduct was more extreme, and a $150,000 penalty if it is deepfake content involving sexual activity or nudity. The damages include both actual damages, but then also this statutory damages regime, similar to copyright infringement, liability damages regimes that exist for copyright statutory damages, where the awards can be to an extent divorced from actual harm and are focused on deterrence and punishment. And there are broad injunctive relief powers available to federal courts to enforce the laws. And as a word of warning, do not let your clients think that until this law is passed, that they are operating on a blank check to do what they want as it relates to artificial intelligence technology. Aside from the state right of publicity laws that we have discussed, there are a variety of state laws that various states have enacted specifically to address improper deep fakes, particularly in sexual and nudity subject matter areas. Finally, this is not the only pending federal law. There are other pending bills that seek to achieve similar legislation over the area, all of which legislation amounts to a partial, at least nationalization of the right to publicity. The legal landscape here is changing rapidly, so stay tuned and watch our programs as we update the state of the law as this develops. This brings us to the end of our program today on artificial intelligence and the Scarlett Johansson and Val Kilmer examples, along with the myriad other examples we have explored. We can start with the premise that AI genuinely is a breakthrough technology for voice creation and imitation, as well as human digital avatar creations and imitation. As we apply this technology to the existing legal landscape, we rapidly confront various state right of publicity laws that will apply in many states to voice impersonation via technology, but not necessarily in all states. And of course, the right of publicity laws are general laws that were not written ever with an eye towards this technology, obviously. The point of importance here is that AI is rapidly creating commercial opportunities to replicate voices, and therefore rapidly augmenting possible right of publicity claims to address the technology, which until advanced software and AI was a fact pattern that required a trained voice impersonator to be in the middle of things, an obviously rare event. Nonetheless, the right of publicity laws are robust and have been around as various different technologies have developed from the early radio and TV age up to the current software and artificial intelligence age. These laws indeed sit on a key legal fault line. The commercial use of someone's distinctive voice for profit in some sort of business ventures as opposed to using sound-alikes in genuinely transformative works or true news situations will confront liability regimes. As we have seen, there are disparate state regimes without a national basis for the right of publicity, and those regimes can provide significant liability, as we saw in the case of Tom Waits, for example, who secured a multi-million jury verdict because of a Doritos commercial, and Bette Midler, who was allowed to go to trial also. We've also seen that there are First Amendment limits built into the laws that obviously protect news and other important social purposes and fair use concepts that sit beneath our entire legal landscape. But even those concerns have been considered by the U.S. Supreme Court and rejected when it comes to a complete taking of someone's persona, as we saw in the human cannonball case. At the same time, it is also the case that defining what is a distinctive voice on one side of the line and what is not on the other side of the line is itself a complex factual question. Some cases will be easier, such as when it is a hired sound-alike hired because the artists refused to participate in the commercial, or when there is something truly unique and widely recognized about the voice. Think, for example, Morgan Freeman. But other cases are harder where the distinction of the famous person is their persona or look, more than their voice per se. And when AI creates the voice, the easier proof problems, as Midler and Waits had, are now going to be potentially absent in many fact patterns if the AI is not expressly asked to sound like a specific person. As this technology is progressing so rapidly, Congress and various states are reacting fast in the deep fake sexual content space. But this will also in time demand that all uses of artificial intelligence for purposes of making deep fakes eventually find some sort of national right of publicity, it appears, one that is broader than just applying to deep fakes in the sexual content area. Finally, not all is bad, obviously. We saw both positive and negative examples of the technology in just the last few years in terms of how it can genuinely help and benefit people, as well as the potential risks. On the positive side of this software and artificial intelligence-based learning, we saw the incredible case of Val Kilmer that has allowed a person who has lost his voice, a distinctive voice in my opinion at least, to regain it and be able to continue to practice his trade as an actor. This was with consent within our laws. There are countless other potential examples of how this technology will provide opportunities to help people in need, as well as benefiting the heirs of deceased celebrities who can monetize their ancestors' voices in ways that are positive for them and the commercial parties they enter contracts with. The potential applications become limitless as you ponder it, all of which will collide with the legal landscape and require robust laws and proper licensing and consent structures. This is why many states have already enacted more robust laws. And of course, it is why Congress is also moving to address the shifting legal landscape that has been triggered by the technology advances as applied to bad uses of the technology. Of course, we as a society can also obviously benefit when we get to, in the coming years, hopefully see Spencer Tracy, Humphrey Bogart, or Katharine Hepburn star in new movies, or one day with AI avatar and hologram technology, we may be able to see the Beatles perform live again. Thank you for watching this program and all our Curious Lawyer programs. And as always, if you have questions, please email me. And you can be safe in knowing that it will not be my avatar that replies to the email. It will only be me,